found it. There we go.
All right, now that we've hit record, I'd like to say welcome to everybody. We'd like to thank you very much for joining us today. My name is Brian Armstrong with Keller Williams Vermont, Strongwell Real Estate Team, as well as Strongwell Property Management. And we've got somebody who I can't stress enough has been an invaluable source of relief, of guidance, Angela Zakowski from the Vermont Landlords Association. And for those of you who may have heard just the last couple minutes, this is a really, really juicy topic. And it's a juicy topic because we have, great community members that may be residents or of landlords, affected. We've got hardworking, wealth-building Americans being affected. And then we've got to balance a big issue, housing shortage. I'm going to encourage anybody to use the question and answers with any questions so that our great moderator, Brandon, can help us get your questions answered. And we encourage people, the more you ask, the more beneficial this webinar, Zoom can be. And I'm already talking too much. Angela.
That's okay. You're giving all of the ground rules, and we usually give folks a couple of minutes to come in. But I think given that we record these so they can be watched after the fact on the Vermont Landlords Association YouTube channel, and that we probably have a lot of things to cover, and hopefully we'll get lots of questions today, I think we should probably go ahead and get started. That just to keep things on task here. So I did actually, oh look, there's my whole screen.
Well, awesome. If I may interrupt you for a second, and I'm going to do it anyway, so you get.
Oh yeah.
If I remember correctly, the brief history of this came up 2 years ago. Was it 2 or 3 years ago?
So this first started in Burlington in the winter of 2020, and so it was actually starting prior to us heading into the COVID situation. There was, I think, a city council meeting that was scheduled, or a community, one of their committee meetings that was scheduled for, I want to say early March of 2020, that ended up getting canceled, partially because I think somebody was sick or COVID really, anyway. But the city council proceeded with this through COVID and through a lot of the lockdowns and through a lot of the remote meetings. There were numerous city council committee meetings and city council meetings on this issue, mostly remote. There were participation by Burlington landlords. There was participation by residents, some who were landlords, some who were tenants, who were residents of the city of Burlington. There was participation by Vermont Legal Aid, though sometimes it was hard to tell whether it was in their official capacity or whether it was just as a person who is employed by legal aid but is here to advocate for this issue. But it's been really spearheaded by Rights and Democracy. So that organization was heavily involved. And so there's been a lot of testimony and a lot of information provided about this type of eviction restriction. I mean, I don't really know how else to describe it. And a lot of concerns raised by the landlord community as it relates to what it's going to do to rental properties, the availability of units, the impact to tenants, both tenants who are following the rules and tenants who aren't following the rules, and that it's not always positive, and yet sort of was pushed through. It was on the ballot for town meeting day in 2021, and was one of the charter changes. There was 5 or 6, I think, that year that were included on the Burlington ballot. And then it spent 2022 in the legislature, which it passed, and then was vetoed by the governor, and there were not the votes to override the veto.
So,
yeah,
it was almost overridden, and we only kept it by 1 vote.
Yes.
Yes. And so this year that could be a real challenge.
It could. The political makeup of the legislature has shifted and changed from last year. So So here we are. So I think let me give everybody just a little bit of background for those who maybe aren't familiar with what we're talking about. So what is a just cause eviction or a just cause eviction framework? It's also known as good cause. And what it does is it restricts, or I suppose you could say prescribes, depending on which lens you want to look through this as, the grounds for which a landlord may evict a tenant. And so the basic premise is that you have to have a reason to get rid of a tenant. So it's a removal of the landlord's ability to just say, hey, the contract's over, the relationship is over, we want you to leave, and we are not giving you a reason. So it removes the no cause notice from sort of the arsenal of available remedies to a landlord when dealing with a tenant. And it gets good press because what it's promoted as is that it is going to improve housing stability for tenants. And then, they try to say it's going to improve housing stability for landlords. Why would you not want that? And that underline it, if a tenant is paying the rent and following the rules, that they should be able to live in a rental property for basically forever, as long as that tenant chooses. So those are kind of the underlying premises. You can go a little bit deeper, and with some of it, it's that landlords are asking tenants to leave for no good reason, that they're doing it for discriminatory reasons, that they're doing it for retaliation for complaining, that, the landlord somehow being a bad actor when they use a no cause notice, because the landlord doesn't have to give a reason for why they're using that notice. And I think, all of you that are in the housing field and provide housing for tenants, it is not a good business model to be just evicting tenants without a pretty good reason, right? Even if you're using a no cause notice, there's generally a reason why you're asking that tenant to leave. You don't want a vacant unit, you don't want to go through an eviction. But there, can be challenges with using some of these other notices.
If I may, Angela, you're probably steps ahead of me. When I was more involved directly in managing our buildings, the issues that to me that no cause was phenomenal for was unregistered guests, a lot of short-term traffic on the weekend. And when I was at one of the hearings in Burlington, people said, well, if you got a drug dealer in your building, the other tenants will go to court with you. I just find that completely unfathomable. So my concern, and I'll cork it in a second, was if this goes through, when we have short-term, traffic issues, we have noise complaints, all this stuff, our hands are going to be tied, and then they're going to leave basically the landlord with the one bad apple. And then pretty soon those buildings or series of buildings will just be bad apples.
Right. Or you are going to have to drag all of your tenants who are complaining to you, your good tenants, into this court proceeding, where the no cause right now provides them some level of protection and you don't have to involve them when there's a problem. So just cause, there's a lot of different versions of just cause, and it's been in place or put into place in the last couple of years in a lot of different municipalities around the country, and sort of everybody's version is a little bit different. And so, with a lot of this, really, the devil is sort of in the details and the nuts and bolts and like what the actual ordinance says. And even with the Burlington charter, just cause charter, we don't actually know what the final ordinance would look like. We haven't even seen that. So it hasn't been drafted yet. So it's we're talking about a lot of things that might happen, but we don't know. And so it creates issues when you're trying to challenge things. So, but one thing that's consistent on a grounds for just cause is that the tenant is not paying their rent. Sometimes that also will include if the tenant's making late rent payments as a basis or a grounds for evicting under this framework. Many times it's intentional damage to the unit. So it's not, hey, something happened or I was careless or I was negligent. It was like you did it on purpose, which from a legal standpoint is a pretty high standard. and then other sort of what they call material non-compliances with the terms of the lease. And the thing about these just cause frameworks is that in the framework, it provides a list of reasons that you can evict a tenant. So if it's not on the list, you can't use it to get rid of the tenant or to ask the tenant to leave. Even if it's causing problems in the building or it's, having some other impact, if it doesn't fit within that list of prescribed reasons, it's not allowed. So you can kind of see what the issue might be here with this framework. So just, for background, so people can see it if they haven't seen the Burlington Ordinance. So the charter change. So the charter change laid out and prescribed sort of broad categories of things that would be in the ordinance. But the details as to what each of these mean wouldn't get decided or written until the charter change came back for the city council to consider it. So the tenant's material breach of the rental agreement, whatever that means. Their violation of state statutes. But again, like each of these categories in the ordinance level is going to have behavior that is described as being a violation of the ordinance and a basis for eviction. Non-payment of rent, so that was clearly laid out in the charter change. The tenant's failure to accept a written renewal term. So if you gave the tenant a lease renewal and they refused to sign it or wouldn't return it, that would actually be a basis for you to ask them to leave. Hey, you haven't signed the contract. You have to go.
If I may interject, in coming off
Yeah.
of my screwing up your presentation, very valuable.
Yeah, no.
One of the people, as people are listening to this, we're definitely going to encourage you, get involved, talk to your legislators, your local reps, all that stuff. But one of the challenges with this, which may be better if it was dealt with at a state level, is that if I understood it correctly, it would go to Burlington passes the charter change, has to get approved by the legislative, then it goes back to be written by Burlington. There's no additional screening by the state. So it's sort of saying, hey, trust us, we'll figure this out. And if what we're seeing out of at least that one well-intended municipality is so heavily, tenant resident favored, you can imagine what the final draft will look like with no opportunity other than to initiate litigation.
Right.
So yeah, it's going to be an important one to get involved.
Right. So substantial damage to the property. Substantial is not defined. There were, at the legislative level, there were some conversations back and forth about what that meant. And there was, I think, at least one version where the legislature tried to define that for Burlington and then that got removed. So, things like substantial damage, well, that would have to be defined. Like, what does that mean? One of the city councilors in Burlington, who is no longer on the city council, but that person's opinion was that it had to be $30,000 or $40,000 worth of damage for it to be substantial damage to the property. So you start to see that this is getting very quickly skewed. So behavior of the tenant that adversely affects the health and safety of other tenants, the landlord or the landlord's representative. So again, adversely affects the health and safety. So this isn't going to be everything, right? It's going to be sort of those pretty extreme behaviors. Does noise, could you make an argument that lots of noise overnight is somehow adversely affecting the health and safety of other residents in the building? It's possible that that doesn't meet the standard.
Then we'll be asking for decibel tests.
Right. So criminal activity on the premises, and I think that maybe they were throwing us, the landlord community, something here with a criminal threat against the landlord or landlord's agent. So, but again, it's criminal activity on the premises. So, your tenant goes out and commits armed robbery at the bank, 2 blocks over. That's not criminal activity on the premises. So under this framework, you wouldn't necessarily be able to evict them.
Yeah, one of the things, and I challenge you, this is politically incorrect, but one of the things when this first came up, I use an example of my first wife, rest her soul. We had a tenant who was very misogynistic, very sort of interface. Now, she was raised by a Marine. She could have whooped him, but you may have similar situations where you have a landlord that physically, for whatever reason, is easy to intimidate. And that would basically mean, if this goes through, the person who rents the property has more rights than the person who owns it.
Right. There was a Burlington landlord, a female Burlington landlord, who came in and testified before the committees at the city level, so at the local level, and told a story about a tenant who would, every time she entered the unit to do repairs or do an inspection or, do anything, would sort of hover, creepily stare at her, follow her around, made her very uncomfortable for her safety. And when that tenant's lease was up, she made the decision to use a no cause notice to ask that tenant to move along, because it just was not a good fit. It was very uncomfortable for her. She didn't feel safe going into the unit. But under this framework, she would not be able to ask that person to leave. And so, that's a very real situation and a very real problem that's going to be created for landlords and for, tenant, same issue if two tenants are having this situation, right? I mean, you've all probably dealt with tenant to tenant complaints. Sometimes it's maybe a female tenant that's coming to say, look, my neighbor's making me feel really uncomfortable. Like, here's what he's doing. Maybe they're able to get a stalking order against him. Maybe they're not. And sometimes a no cause notice is used in that situation. And under this framework, you wouldn't be able to ask that other tenant who's doing like strange things, looking out the window, maybe following that person. You wouldn't be able to ask them to leave, because they don't fall into one of these categories, even though it's not great behavior for the building. So the way the charter was written is, so it lays out these broad categories, and then it included a list of properties that would not be subjected to just cause. So the regular rules would apply. So for sublets, so basically if your tenant's renting a unit, just cause wouldn't apply to them. Or if you are renting a unit in your own home, just cause wouldn't apply to you. If you are an owner-occupied duplex or triplex, so if you're living on site, 3 units or less, you would still be able to use no cause notices, or the just cause wouldn't apply. So again, even within Burlington, we're going to have this patchwork of like, does this unit, is it an exempted unit? Is it not an exempted unit? Starts to create sort of more chaos. And then units that are being withdrawn from the rental market, though, my guess is there's some other requirements that would be applied to that category. Relocation costs or more notice, or, other types of things. It's not just, hey, I'm taking it off the market, so I can give you a no cause notice. Like, we just are seeing these sort of broad brushstrokes. We haven't seen like the actual ordinance that would have sort of the working pieces to this.
And Angela, when I was on one of the meetings with Burlington, I don't know if this is what caused this sarcastically bone to be thrown with landlords. There was a person who was zooming in from Europe saying, I'm in Europe right now, taking college courses. Are you telling me when I move back to the States, I can't move into my unit?
Right.
Now, certainly put this exemption in, but the question then begins, if there's no legislative overview of the final draft, would they have to give 6 months notice, a year's notice? And we all know life happens where sometimes you're doing okay one day, and all of a sudden you may need to realize you need to move in one of your units the next.
Right. I also find it interesting that exempted from this charter ordinance would be properties being sold for owner occupied use. So if you're taking a rental property and converting it back to owner occupied use, they would say, no, that's fine. You can use the no cause or whatever. So, for a city that claims that they need more rental units, like, that's a pathway through that wouldn't do that. It would actually, it's the opposite. But anyway,
you just tagged on something bigger, which is probably probably different segues, all the more reason too, while this is not about Act 250, that anybody that's on today's webinar in the real estate industry needs to help our state move forward in that, because they're picking on the landlords when in reality, even if we went through with a lot of this stuff, I think I heard at NPR something like, even if we went away with Act 250, we couldn't address more than 30% of the capacity needs within 5 years.
Right. Well, and again, this gets back to Vermont has underdeveloped housing units for decades. We have not added the number of housing units that have been recommended for 10, 20, 30, 40 years. And so it's all catching up with us now, but it's being placed on the shoulders and the backs of the landlord community, the short-term rental community. It's clearly all of your fault that this has happened, as opposed to lots of different policies and pressures that have created just a housing shortage across the board. And then we also have this properties in need of substantial renovations. Again, substantial renovations is not defined. So what does that mean? That preclude occupancy. So if, there was some habitability or other sort of deterioration of the rental unit to a point where you would meet whatever substantially was defined as, you could use that as a basis for asking the tenant to leave. But that's not good. You don't want your property to be in that state. And so then there's some other provisions that were thrown in here that we would see having to be drafted. So relocation, right? There may be some relocation requirements. Sometimes those are attached to certain reasons. So fine, you need to renovate your unit, or fine, you're going to own or occupy, but you need to pay relocation expenses for the tenant, like up to 1 month's rent, or something like that. So it's not, even if you're an exempted property, you may not be truly exempted. It's again, we don't know because we haven't seen the ordinance. There is supposed to be some reasonable probationary period after the first lease start date. But again, what does that mean? What does that look like? Is it mean that just cause wouldn't come into effect until 12 months of occupancy? I mean, I don't know, is it 6 months? Is it 1 month? Is it 2 months? Like, what does that mean? Again, we haven't seen these details, so we don't know. And if the underlying premise of just cause is housing stability, so again, I think some of these things sometimes are put in there to be like, look, landlords, we're paying attention to you. We're listening to you, but again, what does that mean? What's the reality? What is that reasonable probationary period? That might be the out for folks if this framework goes in, that you can, during the first year, ask people to leave for no cause, but after that, then this framework comes into effect. We don't know. We don't know what this means because we haven't seen it. The one that they have tried to tell all of us is not rent control, but the limits on unreasonable rent increases. And my understanding is there would be some ordinance prescribed amount that your rent could be increased every year. Otherwise, it would be viewed as being unreasonable. And if that's not rent control, I'm not entirely sure what rent control is then. But we heard lots of, no, it's not rent control. It's not rent control. It's just to keep landlords from raising the rent really high as a de facto eviction. It's like, no, but you're limiting the amount of money I can raise on a unit in a year. It's rent control. So. And then also this was thrown in here that the ordinance has to mitigate potential impacts on small landlords. Again, another provision that I have no idea what this would actually mean or what this would look like, or whether there would be further exclusions from the ordinance if you owned fewer than, I don't know, 4 units or 3 units, or I don't know. Again, it's one of those, I think, things that was thrown in to be like, look, we're looking out for the small guy. We want our small landlords, but we're going to set up this framework that they can't work within, or that makes it challenging to work within.
And Angela, one of my big concerns, and I voiced this, is I think there's two things. The impact is, I remember when I was more directly involved, if I had tenants with questionable credit background, stuff like that, I would end up doing a short lease with a non-renewal, and we could move them along the ways. I could see a situation under this where anybody with marginal credit is just not offered a chance because the person is, don't let these people into my house. I could be stuck with them for years. I think the other unintended impact that I see is, this could create a situation where you have just big juggernaut corporations of landlords, because if they have 100 units, they could handle having 10 evictions or 1 eviction, 2 evictions going on. But real estate being one of the biggest wealth builders in our country, I could see this impacting a lot of families in a generational effect, because they don't get into buying a multifamily property because of these concerns.
Right.
Really affects the or the bundles of rights that we know as real estate.
Right. And then sort of the last provision in this charter was that the notice of these requirements have to be in the rental agreement. So, I mean, that part is what it is. Burlington, you have to attach the noise ordinance to your leases currently. That's not totally unheard of, that you have to have some of these things in the lease agreement. But whatever the ordinance is, they decide that has to get incorporated into your lease in Burlington. So some of the myths, we've been talking about these on and off, that it promotes housing stability, that there's just this sense that landlords are out there just unilaterally asking tenants to leave for no cause, because I don't know, they don't have anything else to do. I mean, a lot, and I say that sort of in jest, but the link that was being made was that landlords are using those no cause notices for discriminatory reasons, which I have a really hard time with, that they're using them for retaliatory reasons. So the tenants complained about something, the landlord doesn't want to fix something in the property, so they're giving them a notice and asking them to leave. And that just the landlords or they are using no cause notices. And I think we're starting to see this argument more to clear out, like when investors, because there's been a few cases, investors have come in, bought a building, cleared out the building, renovate, raise rents, right? That's the model that now I think the focus has shifted to. And that's relatively new. We haven't seen a lot of that here until recently.
Well, one of the challenges of that too is, it's the rights of real estate. And so I may be a little bit over the top on this one, passionate about the topic. I own several rental properties, property management company, but one of those is basically looking at them as, the right of disposition and the right of control. And if we see an opportunity economically to better the real estate inventory and yes, make a reasonable amount of money for doing it. Mm-hmm. So my question and challenge to everybody listening is, and I hope you guys get a little spooked out of this and get involved, is if this cracks one of our key rights in the ownership of real estate, what's the next right that's taken away?
Right. And for what? And is, the state telling property owners that it's your obligation in the private sector to be providing housing and perpetuity for folks? Because that kind of seems to be the message that's coming with this type of ordinance or statute, is that once you're in, and you can't get out at all, for any reason. So I think one of the other myths here is that this protects tenants. I think they're missing a word. So I think it protects bad tenants. If we were going to, assign good and bad to folks, I think it provides protections for tenants who are not following the rules and who are creating chaos in a building. It does not actually protect tenants who are following the rules, because what it does is it drags them into this issue and this dispute, and gets tenants having to be involved in other tenants' behavior. And having to be involved in having that person removed from the property. That's not protecting the tenant that's following the rules. That's dragging them into something. That's getting them to not report things because they don't want to be involved. That's what that does. It doesn't protect the people who are following the rules, it protects the people who are violating the rules.
Yeah, and it's very short-sighted thing. Somebody sees a lot of short-term traffic, stuff like that, that they're going to go to court and then go home to their neighbor who they basically just said was a drug dealer, threaten their, and have the, yeah, that's not going to go well. We both know it.
Yeah. Yeah. And then of course the big one is that, landlords use these no cause notices for discriminatory purposes. Like they're just using them to ask people to leave for reasons that wouldn't be allowed if they had to give the tenant a reason. I view that one sort of as a red herring. I mean, I do eviction work. That's what I do as an attorney. And there's always a reason, and it's not discriminatory. It's usually some sort of chaos or other issue that's happening in the building, and the landlord doesn't want to drag other tenants in to have to prove a breach notice. It's to create stability in the building that these no cause notices are used. And is this other myth out there that landlords are evicting tenants who are paying their rent and aren't violating the lease. Now, am I going to say that never happens? No, because sometimes properties get sold and a tenant is paying the rent and a tenant isn't violating the lease, but the new owner has another plan for that building, or the property owner decides that they have another plan for that building. And so sometimes tenants in that situation are asked to leave. But shouldn't be a bad thing, right? That's the risk of renting. I think
Correct.
If you want to live in the same place forever, that's when you purchase property, because those premises are true.
Yeah. In this tight market, we've counseled at certain times, certain specific examples, nuances, not a general brushstroke. Somebody might be owning a duplex and say, hey, don't renew. If you're going to go to market, don't renew, because your building's going to attract an owner occupied buyer, and we'll probably be able to get you more for the property in today's market if it's owner occupied, again under certain nuanced specific situations.
Right. So just quickly, I kind of ran through this a little bit at the start, but just so folks are aware of like how this process works. So sort of the first step is this proposal is discussed at city council or select board level. So it may appear on, select board minutes or warnings for meetings. So that's one thing you want to pay attention to in your, local municipalities where you own property, and also maybe where you live. Just to keep an eye out, is this something your select board's taking up? If, you can also call city council people or select board members and just ask them, if they're going to take this up or if this is on their screen. And so once a decision's made by the city council or select board to use this process or to try to adopt this sort of framework, any charter changes have to be put before the voters. So it has to be properly warned. It has to be placed on the ballot. We usually see it at town meeting day or at, sort of the November elections. And so it's something to keep an eye out for on your local ballots because it has to have voter approval. And so the voter time frame is another place where this can get shut down. If the city council or select board doesn't shut it down, it can get shut down by the voters who say, no, this is not something that we want to have our city do. We're not invested in this. This doesn't make sense. I think, a lot of times the sound bites are so good for this that if it's on the ballot, you're going to see people voting for it because of course it sounds great. Protections for tenants, like can't be asked to leave unless they're violating the lease or not paying their rent, right? And we understand that that's a little more complicated than that. The next step is if it gets approved by the voters, then that charter change goes to the legislature. So all charter changes have to be approved through the legislature. It's this just Vermont governance here. It generally starts in a legislative committee, and either the House or the Senate. It does have to go through both chambers of the legislature here. It goes to the legislative committee. They take testimony. Sometimes they make changes, sometimes they don't, and then it would get voted out. So all of these steps are if the answer is yes. So at any point, like, this could stop because a vote is no. But we're sort of working through this as if it's yes all the way through, just so you can see the whole process. So it gets voted out of committee, and then it has to go to that full legislative body for a vote. So the entire House of Representatives or House Vermont representatives have to vote, or the entire Senate body has to vote. And it has to again be yes for it to move on. Once it gets voted out of one chamber, it goes to the other chamber to basically go through that same process. Goes to committee, more testimony, there might be more changes to that charter change, or it just gets voted out as is. And so we see a repeat on both sides. If it is passed out of both chambers of the legislature, it is then sent to the governor. And so the governor at that point has options. The governor can sign the charter change. The governor can veto the charter change, or the governor can, to double check, but I know for regular bills, can let become law without a signature. So there's a certain time frame attached. There's no signature. It just becomes law without the signature. I'm not 100% sure if that applies to charter changes or not, but it does for standard bills. So when that happens, then the charter change goes back to the local level. If it needs to then have an ordinance drafted, most of the time the charter change is authorizing language. So it's authorizing the local city council or select board to create the ordinance. So then there's a further step of the sort of the details, and, you know, has ordinance been crafted within the language of the charter change, right? Because that's what they're authorized to do. Has it been drafted to fit within that? So where the Burlington one got to this last year was step 8. The governor vetoed the Burlington charter. It went to the House for attempted veto override, and the veto override failed by 1 vote. So it stopped. It can be reintroduced this year. So Vermont's on what we call a biennium cycle. So bills that are introduced have 2 years to work their way through the legislative system. And this last year, spring of 2022, was the end of a biennium. So any bills that weren't passed by the end of last year have to be reintroduced this year to go forward. I would expect that this Burlington charter would be reintroduced. I haven't seen it yet, but I would be surprised if it wasn't reintroduced with the same push and the same process to have it go through.
You know, Angela, are you seeing other towns actively talking about this as well? I'm imagining
Yes.
Barry's close behind, just because they're usually right in step. I don't know if you've heard anything about Winooski.
So I've heard Winooski's talking about this. I've heard Brattleboro is talking about this. I've heard Montpelier is talking about this, as in like it's being taken up by their local boards, city council and select boards for discussion. There may be others. Those are the ones that I've heard about.
You know, is just as a national picture, I think it was in anybody's listening to recruiting today. I'm not sure these numbers are exactly gospel, but I think it was in California Association of Realtors put $3 million against this initiative in a similar initiative in California. Now, ultimately, it went through in California. So I'm hoping that people get involved first at the local level. State Association of Realtors put up a $30,000 grant the last time this went through. I think it made a dent. And even if we think it's going to pass at the local level, despite vigorous challenges to it, we should fight at the local level to really make our concerns known so that we start to hedge the legislative body's opinion. And then I think we've absolutely got to get to the legislative body, because if we only successfully evaded this or avoided this by one vote,
right,
odds aren't in favor this time around.
right. And I mean, I think it's more critical to try to catch it at the local level before it even gets to a vote. But I think the pleas of the landlord community are falling on sort of deaf ears. It's you know, based on what I saw in Burlington, they let you come in so they can say that it was fair and that they heard from landlords, but they had already decided where they wanted to go with this in Burlington. So it, you know, it is mostly at this point being passed in municipalities around the country. So there's a number of cities in California that have instituted just cause, San Diego, San Jose, San Francisco. And, you know, again, same around, I think New Jersey is really one of the only states that has sort of a statewide just cause framework. Though I will say in many of the places where just cause is going into effect and has already been passed, the eviction process looks a lot different than it does here in Vermont in terms of the length of time and just normal defenses that are available to a tenant for an eviction. I mean, we're talking in some jurisdictions, it's like a week or, you know, less than 6 weeks from start to finish for an eviction. So I don't fully think that we're comparing apples to apples when we're saying like, oh, it works in these other jurisdictions and it makes sense in these other jurisdictions. Well, if your eviction is 14 days from time you start to the time the tenant leaves, that's a different style of relationship. And that's a different process than here in Vermont, where it can take months to go through a process. And there's lots of controls and protections for tenants throughout the entire process. So, you know, we're not actually comparing the same things when, you know, we're hearing like, oh, well, it's worked in Seattle, or, oh, it's worked in San Jose, or it has worked in New Jersey. You know, I was doing a little research on some of those other places, and many of the notices say in New Jersey are like 3 days. And if your tenant hasn't paid rent, you don't even have to give them the notice. Like you can just go right to court and just start your court possession process. So we're not comparing the same framework here when we're looking at these.
You bring up a great point, because I hadn't even thought of that the entire way through. Vermont, you know, I had a buddy who owns property down in Florida, and his evictions are 30 days on average. You know, so in Vermont, I'm thinking bare minimum 3, most likely 6 to 9 right now. And I think that's a great point everybody should make. We have our first question. I'll go ahead and read it. Presuming a town village charter change could also happen at a specially warned meeting. With that presumption, if a town village put forth a charter change and miraculously got yes all up the line, and this happened before the legislative body came up with a statewide rule, would the town's charter change be grandfathered? We're experiencing a lot of drug houses, yet not the level of criminally charged. We want the ability to evict without waiting for the judicial system to catch up. And Susan, thank you for that question.
Right. And I think those are the types of scenarios. I'm going to stop my screen share here. That I think city councilors, select board people, and your legislative representatives need to understand and appreciate. You know, you ask us to take care of these problems. You want us landlords to police this behavior in our building, and you are going to further hamstring our ability to do that with this framework. And so I think that does present a problem, right? If we have these sort of spot just cause ordinances around the state, maybe they're similar, maybe they're not, and then the state decides to do its own framework, that could create some problems. It may wipe out all of those other ordinances and say we're going to have this statewide framework. It could further create this patchwork where it's just a mess. You know, my experience has been we tend to go down the road of it's a mess. But yeah, this is some of the problem. I think we have to be sort of careful though, because if we start too much, the state needs to take this on. There might be the political will this time for, you know, the state to say, fine, we're going to look at just cause for the entire state. They might have the votes. So it, you know, it's, yeah. So the last thing I had up on the slide before I took it down, because I was kind of finding it distracting for myself, was there have been some court challenges that have been successful. Actually, Albany, New York passed a just cause ordinance that was successfully defeated under some property rights requirements, but it's very specific to whatever the property rights rules are in that town or in that state, and then what the ordinance says, and it's sort of at the very end. So it's when the ordinance is drafted, when the statute's drafted, is there a challenge to that because it doesn't fit within, you know, either constitutionally granted right from the US Constitution or the Vermont Constitution or some other property right that's now being infringed upon. And without knowing the details of the various ordinances, it's too soon to tell, but there is that potential. Though I think we've seen every time there is some sort of challenge legally that strikes down one of these just cause ordinances, we see the advocates sort of adjusting, and then in the next place making that adjustment. So they're taking into account those criteria or those things that cause problems in another jurisdiction. So they're sort of evolving and changing as well as these are litigated. It doesn't make it go away necessarily. It just means folks come back and fix it. So yeah. So now that I've brought everybody the gloom and doom, you know, I think Brian started this with, you know, what do people need to do? And, you know, I think the big one is to be paying attention as to what's going on in your local municipalities. It's hard to monitor that for places where you own real estate if you don't necessarily live there. I think your voice has more impact if it's in an area where you also live, right? Because those are people you have voted for. Those are people that are your representatives that are supposed to be your government working for you. So, you know, you have to keep an eye on the select board warnings. They all have to warn their meetings. And it's got an agenda, tells you what they're going to be talking about for a particular meeting. Many still have the remote option to be able to Zoom in if you can't attend in person. So that, you know, not all, some are starting to go back to you have to show up in person to participate. But, you know, those are places. And for sure, Montpelier, Winooski, Brattleboro, I know that this is being actively discussed within their city council and select boards currently. I'm sure there may be others, again, that I haven't heard about, but I know those are the hot cities right now for this topic. You know, Rights and Democracy had a list. They shared it with Digger, and there were a few other towns on there. So.
Are there any questions from the group? Because I've got a few other ideas, but as always, first and foremost, we're grateful for your participation today. Secondly, we'd love to see you on, and the more questions we have, the better we can bring you value. And while anybody's thinking about questions, you know, to me, Angela, it's hitting on all fronts. I mean, one of the things I'm going to walk away is ask a team member to check the town meetings in the immediate area, especially where we own property.
Right.
so that we can better participate. The other thing, as passionate as I was today, I'd probably be more diplomatic if I was at it, at a team meeting, to sort of invite the people to not only appreciate the validity of their perspectives, but also think of these additional things and
Right.
ask serious
Right.
questions.
And I think, you know, if you're going to speak before one of these meetings, be prepared, maybe write out some notes of things that you want to share. If you have sort of personal experiences, like the woman landlord in Burlington who had a very specific situation that would have been impacted by this type of rule, I think it's okay to share that. You leave names out, leave addresses out, that sort of thing. But those anecdotal stories have impact. I think it's also fair to let folks know that look, this is going to make it harder for tenants to find places to go. Landlords are going to not be taking as many chances on tenants if this type of framework goes through. Somebody that is a maybe right now is probably going to be a no. And I think the other piece here that gets missed a lot is if we go to this just cause framework, the issue that the tenant is having in this building is going to be front and center for everybody to see. It's going to be in a notice that you are now required to give to the tenant. And some folks may say, great, we're going to start passing around these tenants that are causing problems wherever they go. But it is something that I think regulators need to understand, that it's going to have a negative impact on tenants. It's going to make it harder for them, because right now there is always a reason that the tenant's getting that notice. And if you want us to write it down, then that's what we're going to have to do. And we'll have to prove it, and we'll have to drag these other tenants who are being disturbed or who have been assaulted or who have had bad interactions with this person or who feel threatened. Like, just it's gonna be a mess.
Any additional thoughts, questions that come to mind from anybody in our audience? Again, we welcome them. If I may offer, any other suggestions to talk with your legislator, your local municipalities, is not so much trying to convince them necessarily it's a bad thing, but oddly enough, convincing them that the other side, being the landlords, property management, the real estate agents, may have a point worth looking at. The difference is, we go into a political debate with our friends, we're never going to get them 180 degrees. But if we can get their belief system cracked just a little bit, they may actually become more inquisitive about our perspective.
Right.
That helps erode any hard, lines against it.
Right. And I think James just raised a good question that it's going to add to the backlog of court cases. I mean, this was a premise and a myth that I probably should have added to the list, is that it reduces the number of evictions. I don't know that it's going to reduce the number of evictions. I think it's going to make the evictions perhaps more complicated and more time consuming, and it's going to require more court time, which means it's going to take longer. It's going to clog up the court system more. So it's not, I don't see it as causing a decline in the number of evictions that are filed. I mean, maybe a few people would think twice, like, oh, well, I don't want to hassle with this if I have to go through all of these, I have to drag in other tenants and I have to do this, that, and the other. I don't think we're gonna see that great reduction in evictions, which is one of the things that the advocates are promoting, right? Housing stability, reduction in evictions, like I don't see it happening.
Road to hell is paved with good intentions.
I mean, it's going to increase the cost to the landlord, which in turn is going to increase the cost to rent. But then you're going to be sort of strung by that rent control that's been snuck in there, because you can only raise the rent a certain amount every year. And we do have just cause evictions in sort of a couple of housing segments in Vermont. One is in mobile home parks. And, we see mobile home parks being added all the time to our housing stock. Nope. That was really tongue in cheek. So it, hasn't necessarily been a positive over there. We also see this type of framework in subsidized housing. But that's subsidized housing, right? Those housing providers get lots of federal funding and other monies and other financial advantages that aren't available to folks in the open market. So.
Looks like we've got one more question as well from Aaron Kirkpatrick. Actually, we've got another one as well. Do you have some solid arguments we can bring to the select board and or city council meetings, or things we should avoid using as arguments? I want me to make my points without coming across as a greedy landlord who doesn't care. Andrew, is Aaron typed this in? I was thinking of almost whether it's the association, if we could hand our members or even our clients, some bullet points of these are salient options, because I grew out of today's, thinking not only the court system, how it could get overloaded, to, a series of other things. So maybe that's a great a talking point or a white paper or something like that from the association.
Yeah. And I'm happy to put out some of the statements that I've made before the legislative committees. I think one of the biggest, and at least in my mind, one of the more solid arguments is that this doesn't actually protect tenants. It protects tenants that aren't doing what they're supposed to, but it doesn't actually provide protection for tenants that are following the rules, particularly if they have a neighbor that's not. Because that tenant who is following the rules now has to become involved in this process in order to have that sort of not good neighbor removed. So it actually sort of does the reverse of what everybody says it's going to. And it creates more burdens for tenants who are actually following the rules and providing the landlord with information of neighbors who aren't following the rules. And so in that sense, that's not a tenant protection. That doesn't really help that situation. It just creates a culture where a tenant isn't going to come to you to say, hey, this is going on in the building, because now they don't want to get involved.
They're just going to leave.
They're going to leave and go somewhere else, or they're going to live there and be subjected to the bad behavior of another tenant. I think it's also going to create scenarios where whatever the behavior is doesn't fit into one of those categories. And so it may be not good and it's causing issues at the building and it's creating sort of chaos, but if it doesn't fit into one of those categories, then you're kind of stuck.
Yeah. We've got one more question as well. Dan, thank you very much for participating today. In Brattleboro, they've gotten the signatures needed to put it to a vote for a charter change. If this goes through in the context of cost of living issues and the end of emergency rental assistance happening along with this, what would be the best case scenario of action that a municipality might take to mitigate the impacts of this change and or enforce it? For example, more safety and health inspections to support landlords.
I mean, possibly. And I know, Brattleboro, from my understanding, has a pretty decent health and safety inspection program. So, those inspectors may end up getting some more work or having to do more work or more inspections because the landlords are going to need some of that information at times. But I think that it is, I think you've hit sort of on part of the issues. We've had sort of this 2 to 3 year period where there hasn't been a whole lot of responsibility placed on one party in this relationship. They've been able to have rental assistance for a really long time. There was the eviction moratorium for a very long time. And, landlords have borne the brunt of that time frame and of that period. And then to further sort of pile on regulations, it's going to exacerbate the housing issues that we're seeing, right? It's going to increase costs. It's going to cause units to come off of the market. Like, I don't I don't see this as being a benefit and creating the outcomes that the advocates say are going to be created. I think it's going to contribute to the worsening of the housing market and the rental market and the rental costs. And then, and then what? Right. So they put just cause into place and it still doesn't fix these things. What's next? What's next to blame on the landlord for the situation that has been created and placed on the landlord.
Yeah, James Unsworth made a great. James, hope you're doing well. There'll be a mass of no cause evictions if this gets passed. Landlords will get rid of anyone questionable.
Right. So not only will you clean house leading into this, but anybody questionable is not going to get through the door as a renter.
And the last thought I would encourage people to echo is it's not about who's got more rights. It's about equity and balance. Balance.
Right.
And Angela, one of the greatest points that you made is just how long our eviction process is already compared to the other states that passed it through. So with that being said, folks, it is 1:01, and I apologize to anybody who watched me watch my turkey soup in the beginning, or eat my turkey soup, that is. Angela, it's great to see you.
Nice
Angela, to see you. Vermont Landlords Apartment Owner Associations, phenomenal organization, saves us tons of pain and helps us advocate. Please register with them if you haven't or sign up. Brian Armstrong, Strongwell Property Management, the Strongwell Real Estate team at KW. We're grateful for you guys, and let's help further the rights and the balance between our appreciated leasing residents and our owners who provide housing in the community. Last thought, let's help shift this argument away from landlord tenants more to Act 250. We need more housing.
Permit reform.
Yeah. Thank you guys. Have a darn good day. Sorry, Angela.